You're live.
Hello and good afternoon. My name is Deborah Kolchiski and I am with the Tourism Industry Association of BC. I come to you today from the unceded territory of the Kwantlen First Nations here in Langley. And I wish to thank them for caring for this land, as it's truly an honor to live here, to work here, and to play. It's my pleasure this afternoon to introduce this next session on COVID-19 employer rights. I'm starting with Arun Subramanian. He's the Director of Industry, Health and Safety for Go2HR. Arun joined the Go2HR team in 2017, and he has over 15 years of HR experience in various sectors such as hotels, airlines, retail, and facility management. Arun leads Go2HR's Industry, Health and Safety program, which focuses on helping tourism employers create and maintain safe workplaces and communicating the importance of occupational health and safety in staff recruitment and retention. Arun, it's great to see you again, and over to you for further introductions.
Thank you, Deborah, and good afternoon, everyone. Before I begin, I too want to acknowledge that I'm coming to you today from the shared unceded traditional territory of the Katsi, Semiahmoo, Kwantlen, and other Coast Salish peoples on whose lands we work, live, and play. So Go2HR, for those of you not familiar with us, is the Health and Safety and HR Association for the tourism and hospitality industry in BC. Yesterday marked a grim anniversary in our beleaguered world, 1 year since COVID-19 was declared a pandemic. As you know, the impact of this pandemic has been exceptionally high on our societies, but also on our industry in so many ways. Finally, though, we are beginning to see the light at the end of the tunnel. Despite a slow start with vaccines, they are slowly being rolled out across the province at a much greater pace today. And with that comes the hope that tourism, as we knew it, will return to the province and businesses can reopen or ramp up their operations. However, the vaccine rollout has also been creating some anxiety for employers as they try to understand the impact of the rollout on their workplaces. Can they insist that their employees need to get vaccinated? Can they ask for proof of vaccinations? Do they need to accommodate employees who cannot or do not want to get vaccinated? And how can they support their employees best under these circumstances? To navigate through these fairly murky waters and answer some of these pressing questions, we have two very astute lawyers joining us today. I would like to welcome Ryan Anderson and Natasha Jategaonka from Mathews, Dinsdale and Clark, a national labor and employment law firm. They're based in Vancouver and are very familiar with the tourism and hospitality industry, having offered many such sessions in the past. Not only do they have significant experience in matters related to employment law, Natasha is also in a previous life an epidemiologist. So without further ado, I will hand it over to them to help us understand employers' rights and responsibilities in COVID-19 testing and the vaccine rollout. Over to you, Ryan, and thank you for being here.
That's great. Thank you very much. And I appreciate you pointing out that only one of us is an epidemiologist, and it's not me, but I will still kick things off. I'm going to share my screen here with you all and walk you through our presentation. Thanks again for having us. We have a reasonably packed agenda in a fairly short period of time, so let me get straight to it. I'm going to talk to you about the topic of vaccinations in the employment context by walking you through the topics you see before you, starting with a little introduction and then some discussion about the developing case law in this area. Then I'll turn it over to my colleague Natasha, who will talk to you about some of the other considerations associated with vaccination policies in the workplace, and then we'll leave some time for discussion and questions at the end. Arun, you're right, of course, on the timing. It's been a year, and in fact, personally, I remember it was almost exactly a year ago today that I was in a mediation at the Labor Relations Board that went much longer than I expected. And it was 8 o'clock or 9 o'clock at night, and I was driving home and I was starving. So I stopped at a restaurant for a beer and a bite to eat. And as I was sort of going through my thoughts of the day, I saw on the television screen that the NBA season was going to be suspended. And I didn't quite process that. And I put my head down and had a few more bites, and I looked up and then it says the NHL is going to follow suit tomorrow. And I remember thinking to myself, how long was I in that meeting? Because for me, that was sort of ground zero. of the introduction of this epidemic. And of course, you know, we're pandemic. We're headed in the right direction. I think we're all a little frustrated because we're so excited about the light at the end of the tunnel and vaccinations coming our way. But this is the context that we're in the context of this presentation with respect to vaccinations is, you know, we're at the end of a very challenging year, in the middle of, hopefully towards, maybe trending towards the end of a second wave with concerns about a potential third and different variants of this. We know that vaccination is likely to ramp up. We've had promises from our governments that maybe by the fall, September, or even sooner, we'll have universal access to vaccinations. And of course, no mandatory vaccination policy is going to be effective before we have universal access to vaccinations. So we're not talking about this kind of a policy being effective until probably the fall of 2021. And that's the question today is when will that work? And do we want mandatory vaccination policies? They'll work in some circumstances, but as you'll hear today, it's always a balancing between human rights and privacy issues along with workplace and worker safety. The key issues for employers and the pitfalls are numerous. You know, we're going to see complaints, and we've seen some in so many different contexts. So human rights, employment standards, occupational health and safety and privacy. In a union context, we'll see grievances. And in fact, those are sort of leading the charge right now in the development of the case law. And we'll talk to you some about some of those early decisions. Lawsuits in the courts, constructive dismissal, wrongful dismissal claims, workers' compensation claims, about safety in the workplace and you know, COVID in the workplace and becoming infected, as well as potential charter challenges in the government context. And what's going to happen is that each of these different areas will be grappling with this new issue and developing new law at the same time. And when this happens, and it's happened before with other instances, you end up with conflicts in the law and different lines of authority. And it's going to take some time for us to sort our way through this. So I'm going to share with you some developing case law in this area. And I'm going to do that by talking about 4 different areas. And that is mandatory testing, as well as dealing with absences related to COVID, brief chat about protective equipment, and then what do you do with those employees who aren't following the safety instructions that employers give them, the COVID-19 protocols. So beginning with mandatory testing, we're all generally now familiar with nasal swab testing. That seems to be the predominant and arguably more accurate form of testing for COVID. But we're also seeing the development of rapid testing mechanisms such as saliva testing. In fact, I've been to one of the ICBC locations converted to a testing lab with my daughter as she swirls and spits because she had a runny nose. So we're seeing these sorts of things. Now, when they are proposed in a workplace setting and potentially in a mandatory way or even administered by employees, we see complaints and concerns from employees, and they're articulated these ways. They are inherently intrusive. You're asking for a body fluid sample or a sample of some sort. I understand the nasal swab thing. I haven't had it done yet, but I understand it can be relatively uncomfortable and arguably even painful. There's been some reports of nosebleeds and such, and that's obviously of concern for employees. We've seen complaints. You'll see one in a case we'll discuss about testing not being universal. So in a care home setting, for example, one of the grievances was that while you're having workers submit to this testing, you're not administering the test to all of the people in the care home, and that doesn't seem fair. Or otherwise, some employees are being tested and some employees aren't, and so you have issues that can arise there. As well as the complaint that testing only provides a snapshot. If you're going to have a mandatory testing policy whereby everyone's tested on Monday or every 14 days, you know, there's an argument that that result is useful for the first couple of days, but then of course you could contract COVID on the Wednesday or Thursday throughout the week. And so what's the point of the testing if it's only useful for a couple of days? That's sort of some of the things we're seeing from employees and from unions concerned about testing in the workplace, but also consider this in the context of the law generally. Our Supreme Court of Canada has considered testing in the context of drugs and alcohol, and they've said things like, this is a near quote, taking samples from a person's body invades an area of personal privacy essential to the maintenance of human dignity. Now that's our Supreme Court of Canada saying that you ought to tread quite lightly when you're asking an employee to share his or her bodily fluids with you for the purposes of medical testing. It's a very, very dicey area. So some cases, you're going to hear from us talking about a couple of different cases today, and you'll find that they're coming from the labor and employment, the labor context, unionized workplaces. And the reason for that is because they're often out first with disputes, grievances that they're then pursued in front of an arbitrator and decided. They are still guiding for non-union workplaces. They're picked up by the courts and the other tribunals. And so they're sort of the canary in the coal mine of what to expect. And so in this case, a case about mandatory testing at a care home, a retirement home, that had not had any outbreaks. There wasn't any COVID issue, acute issue or an outbreak at hand, but the employer instituted a mandatory COVID test every 2 weeks. The union filed a grievance and complained that it was unreasonable and that the testing should only be administered to systematic employees. The arbitrator heard, of course, arguments from both sides and deemed that the policy was reasonable and said that a proactive approach was justifiable in advance of an outbreak. And in that respect, the arbitrator said, when one weighs the intrusiveness of the test, a swab up your nose every 14 days, against the problem to be addressed, which is preventing the spread of COVID in the home, the policy is reasonable. While the home had not had an outbreak, I agree entirely with the employer, given the seriousness of an outbreak, waiting to act until something happens is not a reasonable option. And to this question about, well, shouldn't it only be administered to symptomatic employees, we see the arbitrator quoting Anthony Fauci, saying, Anthony Fauci had this to say about that. If you only test people who are symptomatic, you're going to miss a very large contingent of the spread of infection in the community. Now, context is key. Here's an example of a very recent case that says mandatory testing policy, a mandatory testing policy once every 14 days was reasonable in the context of a care home, where the folks in that care home are obviously at high risk and inevitably in close contact. That precedent isn't going to apply in all workplaces, but we should think about it in the context of hospitality and tourism, in as much as you do have circumstances where close contact and close quarters will be a feature of your business. So we'll watch to see this case law develop. Now, there's an alternative to mandatory testing administered by the employer, of course, and we've given lots of advice to employers who have addressed employees who attend work and they're symptomatic or otherwise have had close contact. And that's, of course, directing them to the health authority to have testing performed, and then they come back with proof of a negative result. Or if we're not sure whether testing is even necessary, have the employee call 811 and follow the advice of the health authority. Test, stay home, self-isolate, or self-monitor. In other circumstances, you might send an employee to their GP, sometimes with direction and specific questions for the doctor to answer to get a confirmation that the employee is fit and safe to attend work. So there's some developing law in the area of mandatory testing. Another real practical issue that employers face is what to do with those employees who can't attend work either because they have contracted COVID. That's usually more straightforward. But what about the folks who've had close contact and are directed to self-isolate for a period of time? And that real question hits the road in terms of, are they going to be paid for that? No doubt, under the BC Employment Standards Act, those folks who are directed to mandatory quarantine are entitled to a job protected leave, but what about, are they paid? That's really a contractual question in terms of what are they entitled to under their employment contract or their collective agreement in terms of paid time off. And that strikes the question, what qualifies as sick leave? What we're finding is that most employers are treating this as a sick leave, even though the employee might not be demonstrating symptoms or actually be sick. The fact is they are unable to attend work for a medical reason. And that medical reason is the fear that they may have contracted COVID, and that's usually being treated as sick leave. So if there's an entitlement to sick leave when you're unable to attend work for medical reasons, then by all means access it. Other employers provide access to vacation time or banked overtime or wellness days, etc. Of course, directing employees to government available income assistance. But at the end of the day, there is no inherent right to regular wages to pay for an employee who is unable to attend work due to being directed to self-quarantine. And that's sometimes not well understood by employees. And in fact, here's another case. It says Toronto Terminals, but that's the name of the employer. But in fact, this is a British Columbia arbitration case from 2020, where the griever claimed pay for a 14-day quarantine following a possible exposure. And in fact, the quarantine was directed by the Fraser Health Authority. The employer directed the employee to short-term disability benefits and serve, a combination of which the employee received, but it still amounted to less than full pay. And essentially the union's argument was that, look, the employee was not sick, wasn't unable to work, but was merely self-quarantining and following the rules, and therefore should be entitled to regular and full pay. That case was dismissed, and the arbitrator found that the employer had issued a clear and reasonable policy that periods of mandatory quarantine would not be paid. And that is a principle that we adhere to, that this is really a contractual question, and there isn't any inherent right to be paid when you're off work due to quarantine. Protective equipment is an issue that comes up. There's not a lot of case law on this. Our impression is that's because for the most part, employers and employees are following the direction of occupational health and safety authorities and CDC authorities across Canada, as well as the public health order. So we don't see a lot of cases litigated, but we did find a couple, both out of Ontario, none out of British Columbia. One is St. Anne's Country Inn and Spa, and in this case, in September of 2020, there was an occupational health and safety order following an inspection that employees in a prep kitchen all had to wear masks because they couldn't social distance. So it was a mandatory order that they wear masks at all times in the workplace. And the employer objected. The objection was a little weak in my view. They said, first of all, look, we'll make masks available for voluntary use, so we don't need an order. Most people will just comply. The employer said, we fear that some employees might have medical issues and not be able to wear a mask without any real evidence to support that. Similarly, they argued that masks impair communication and might create a safety hazard without a lot of evidence to support that. And those objections were readily dismissed quickly in a short decision where the adjudicators said, absent any other protective measures, a mandatory mask order is absolutely reasonable. Similarly, in Maplewood Nursing Home, another case somewhat like this, there was an occupational health and safety order to install a temporary plexiglass barrier at a nursing station in a care home. And the employer objected there, saying, look, the plexiglass isn't necessary because everybody on staff is wearing PPE. That objection was dismissed, whereby the adjudicator said installing the glass was consistent with health and safety regulations, and it's always reasonable to err on the side of caution. The employer had a number of arguments that it was unnecessary and it was going to be burdensome for the staff and the residents to interact, and it was just another surface to clean, et cetera, but none of those arguments carried any weight. And we expect the same results in British Columbia, and I think that's why we're not seeing a lot of litigation in this area, is that when, occupational health and safety orders, public health orders, and CDC guidelines are made, you're not going to have a real great chance of success with objections to those things, absent really extraordinary circumstances. There's some great information. I'm not going to go through it in detail. We do find that ferreting your way through the WorkSafe BC website can be a challenge. There's a lot of different rabbit holes, but there is some very helpful industry-specific guidelines and information. So here's a couple of links that might be useful to you. I couldn't help but pull this picture from WorkSafe BC's website. These two illustrations come from a page that tell you how to wear a mask. And this gentleman appears to have the mask completely over his face, including his eyes. And I thought it was funny. I thought, I don't think that's what they had in mind. The little X is meant to say, don't touch your face. I think he's just trying to get it off his eyes. I couldn't help but share that with you. And I'll conclude here before I turn over to Natasha to talk about what about those employees who refuse to follow safety protocols. And, whether we like it or not, this issue of masks and many different elements of COVID generally have become somewhat controversial, somewhat political. And so we are seeing from time to time some pushback from employees who feel like it's quite the infringement on their personal freedoms. And what we say here is, just like any safety instruction, whether it's steel-toed boots or protective gloves or glasses, et cetera, in the workplace, when you give an employee an instruction related to safety, if it's reasonable, it's not up for debate. If the employee attends the workplace and they seem to have a terrible flu before COVID, before a pandemic, you as an employer had the right to say, you're not well, I'm going to direct you to go home and not be at the work site because it's not safe to those around you. When an employee refuses to follow those reasonable instructions, then the appropriate response is disciplinary. And there's a case on point from also from Ontario, Acon, where the griever was exhibiting COVID-19 symptoms, and he was explicitly told not to attend the workplace until he was directed to do so by the employer. The next day he attended anyway, and he went through the health check and said, oh, I'm perfectly fine, and denied that he had a runny nose and some other symptoms. And he was dismissed for failing to follow that stay-at-home direction in a unionized environment where upholding dismissals for just cause is more challenging. Now, he had a bit of a disciplinary record as well, but at the end of the day, the arbitrator said that the griever's deliberate and cavalier attitude towards COVID safety risks was unconscionable, unreasonable, and totally unacceptable. And again, I think you'd find the same support in British Columbia for disciplinary actions and up to and including dismissal for employees who refuse to follow safety protocols related to COVID-19. So some lessons learned for tourism and hospitality sector. First, context and circumstances matter. If you go searching for a case that says I can absolutely administer testing in the workplace, and as Natasha's going to talk to you about vaccines, you'll be misled. You really need to look at the context and the circumstances on a case-by-case basis. Most of the law that we're seeing that's supporting these sort of mandatory policies are coming out of the healthcare sector, and we'll see how that law develops and expands. Always consider alternative protective measures as well as alternatives to testing, and Natasha's going to talk to you about some alternatives to mandatory vaccination policies as well. Safety protocols, access to paid leave. The real key for employers is be familiar and up to date with the rules. They're changing, they're complex, sometimes they're hard to find, but the best thing you can do is educate yourself. And then finally, as I just discussed, managing safety in the workplace, don't get sucked into that political debate with an employee. Have confidence that if your safety protocols are reasonable and clearly communicated, they can be enforced, and if an employee refuses to follow those instructions, disciplinary action will legitimately ensue. So with that, I'll pass it over to you, Natasha.
Thanks, Ryan. So can you go to the next slide, please, Ryan? So I'm going to dive right in because related to COVID-19 vaccination policies, there's two main questions that we've been getting from a number of different employers. And the first one is, as an employer, do I have an obligation to make sure that my employees are vaccinated before they come to work? So should I be checking immunization records? Is that going to be something I have to do down the road? Is the government going to make vaccination mandatory? If not for everybody, then for specific groups of workers? The second question that we're getting is, can I, as an employer, require that employees become vaccinated? So if the government is not going to make it mandatory, can I decide that in my workplace, I want all of my employees to be vaccinated because I consider it to be a safety issue, and I want to take steps to protect my employees' health and safety, as well as the members of the public that they interact with? So we'll touch on both these questions. Going to the next slide. So first, looking at the first question, is there an obligation to ensure vaccination? At this stage, no. There's no legislation in BC currently that requires any specific group of employees to be vaccinated for COVID-19. That includes even healthcare workers, nurses, and care aides. Now that may change. Just because it doesn't exist now doesn't mean it won't be implemented in the future. As I'm sure you can appreciate, the laws regarding COVID-19 and safety in the workplace have been changing rapidly over the last 12 months. But it's also not something we anticipate. Our provincial health officer, Dr. Bonnie Henry, was asked very early on during the pandemic whether she anticipated making vaccination mandatory. That was at a time that there was no vaccination that had been approved in Canada. And at that point in time, she said that she didn't think that it would be made mandatory. So it's unlikely to change, but still possible. Now, employers do have a general duty obligation under occupational health and safety legislation to ensure safety in the workplace. That's not specific to the pandemic. That's not specific to vaccination. That's just a general duty to take steps to ensure that the workplace is safe for workers and for members of the public. There have been some questions raised about whether or not vaccination could be considered obligatory under that duty. Our view is that it's unlikely. If there isn't legislation in place that is mandating certain groups of workers to become vaccinated, then it's very unlikely that an employer would be held accountable under the general duty to implement something in the workplace. Now, under that general duty, there are things that an employer has to do, for example, like providing education and information to employees about hazards in the workplace, or, for example, providing training. We've seen that already related to certain protocols that are in place related to COVID-19. That could be a possibility relating to vaccination. So, for example, warning employees about what the hazards are in the workplace as the pandemic continues and the vaccination does become more generally available, but not a requirement to make the vaccination mandatory. So that leads us to the next question, which is, can I, as an employer, on a voluntary basis, decide, in the absence of any government legislation, that I want to make vaccination mandatory in my workplace? Now, our view is that an employer may, in some circumstances, implement those types of policies in the workplace. And in order to be a lawful policy, that policy must be reasonably necessary and it must be rationally connected to the workplace. And of course, we'd encourage you, if you're thinking about implementing such a policy, to seek legal advice on the particulars. If you go to the next slide, thanks, Ryan. So you might be thinking to yourself, reasonably necessary and rationally connected. What does that mean? Sounds like a lawyer came up with those phrases. You might be right. I mean, the shorthand is that in order for a policy to be considered reasonably necessary, most likely in this context, what we're looking at are workplaces where a worker has frequent and close contact with a number of other individuals, whether it's other workers or other members of the public who might be coming in and out of the business. But it might still not be reasonably necessary if it can be shown that there are other sufficient precautions that are already in place. And that brings us to we're at sort of a tricky point in the pandemic in that regard, because if your business was closed down last year and then reopened back around June or July, obviously you had an obligation at that point in time to implement a safety plan and to demonstrate to WorkSafe BC that you could operate safely. And that's when we saw a lot of protocols being put in place with masks and plexiglass and limited numbers of people being inside in an indoor space at any given point in time. So with those protocols already in place and sort of an obligation on an employer to demonstrate at that stage that they can operate safely, it then potentially becomes a bit more difficult to say, well, no, it's still reasonably necessary in my workplace because I'm worried about employee safety. Now, at the same time, we do expect that as vaccination becomes broader, that some of those public health requirements are going to change. And so in particular, the number of people that you have in an indoor space, we do expect that will eventually start to change and those practices will start to change. So could that lead to down the road an employer saying, no, now that we have more people indoors, I do feel that it's reasonably necessary for my employees to become vaccinated. So it is a tricky situation. It's going to depend on the science. And of course, our science is continuing to change on this. At this stage, the actual impact of the vaccination on transmission rates is still sort of unknown, although obviously the scientific evidence that we have so far is pretty encouraging in that regard. So a question that often comes up as well is, okay, well, let's say we don't put in a mandatory vaccination policy. Does that mean that if my employee decides not to get vaccinated and then contracts COVID-19 at work, that I could be held responsible under a workers' compensation claim? And the answer is yes, that can happen. We're already seeing that WorkSafe BC is accepting certain claims for compensation for what's called work-related COVID-19. There are sort of two main criteria that need to be shown for work-related COVID-19. The first is there has to be evidence that the worker actually has COVID-19. That can be in two different ways. One could be an actual diagnosis of COVID-19. It could also be through the use of non-medical factual evidence, which is sort of understood to be where there are other cases of COVID-19 associated with the workplace. The second thing is that the circumstances have to be such that the nature of the workplace is one where the risk of contracting disease is significantly greater than the ordinary risk for the public. So again, it's going to be in those circumstances where a worker does have to interact with a number of different people, be they other co-workers or members of the public. We haven't seen information from WorkSafe BC in terms of which industries have been considered in this way. We're still in the early days, but we do expect we will start to see some more of those claims as well. So you might be getting a sense at this point, and Ryan touched on this early in the presentation, that the decision to implement a mandatory vaccination policy or not is a bit of a balancing act of these different considerations. Another consideration that comes up, of course, is privacy concerns. If an employer does decide to implement a mandatory vaccination policy, certainly there should be measures in place to consider how the information that an employee discloses to you is going to be collected, used, and potentially disclosed to others. Potentially, you will be collecting very sensitive health information. Information about whether an employee has been vaccinated or not could be considered sensitive. Also, if an employee is seeking an accommodation or an exemption of some kind, potentially you're collecting other medical information. Maybe the person is immunocompromised and there's an underlying medical issue. Maybe the person is pregnant and has been advised by her doctor not to be vaccinated. This is all sensitive medical information, and you'll want to have a plan for how you're going to handle it before implementing a mandatory vaccination policy. Perfect. So one of the things that comes up quite a bit in relation to the topic of mandatory vaccination policies is the idea of employees' rights being violated. We hear this all the time, an employer can't do that because it's contrary to human rights. Now, the legal framework for human rights has a number of different sources. One is the Canadian Charter of Rights and Freedoms, but that applies to government bodies and government institutions. If you are operating in the private sector, you're operating a hotel, a restaurant, a business of that nature, most likely you're going to fall under the provincial human rights legislation. So we're going to touch on the BC Human Rights Code. The BC Human Rights Code protects workers from discrimination on a number of different grounds, many of which are not especially relevant to the issue of vaccination. There are a few which are bold on this slide, which could potentially come up in relation to vaccination. So an employee could say my religious beliefs or my underlying medical condition prevent me from being vaccinated. An employee might say that, well, I'm pregnant and I don't want to be vaccinated because the risks of the vaccination for pregnant women are not known, and that's related to my sex. And so therefore, I should be exempt from a mandatory vaccination policy. We could also see employees making arguments on the basis of political belief. Now, this is an interesting ground in BC. It's clear in British Columbia that political belief for the purposes of the Human Rights Code is not limited to partisan politics. So it's not just whether you're a Liberal supporter or a supporter of the NDP or any other political group. And it's kind of been left open-ended, actually, in terms of what can be considered an employee's political belief. So certainly we may see some challenges to a vaccination policy on this ground. So if an employee does request an exemption from a mandatory vaccination policy, an employer is not required just to take the employee's word for it. Certainly you can ask for more information. In particular, you can ask for medical information just as you would for any other type of accommodation. You can ask for proof that it is contrary to religious beliefs or political beliefs. It's always a good idea to adopt a case-by-case approach. There isn't going to be a one-size-fits-all type of approach to this sort of thing because the employee's beliefs or medical condition is going to differ from one person to the next. Now, there are situations in which an employer could potentially deny a requested accommodation on the basis that it would cause undue hardship to the employer. And this is where the employer can show that there is a bona fide occupational requirement and that mandatory vaccination policy must stay in place. Now, a bona fide occupational requirement, or BFOR, is a high threshold to establish. The best advice, if you are faced with a situation in which you are asked for an exemption to a mandatory vaccination policy, is going to be ask lots of questions, find out what the basis is that the employee is seeking the accommodation. If the accommodation is one that is easy and causes minimal disruption to your business, and it's one that you're prepared to provide, then provide it. And if you're in a situation where you're not able to provide it or you're considering refusing it, be sure that decision-making is going to be based on the facts. And in the context of COVID-19, more than likely, that's going to be based on the scientific evidence that's available at that point in time. So moving to the implementation of what a mandatory vaccination policy might look like. We do have a little bit of background on this, and we've talked about these points earlier in the presentation. So the context that we're in right now is that there's no current legislation that's mandating the vaccines. The science is changing, and we don't expect there to be legislation that's forthcoming in the near future. Now, the issue of vaccination is not exclusive to COVID-19. Certainly, we've seen similar issues arise, particularly in the context of influenza. And there have been a couple of cases in BC that have looked at influenza vaccination policies. Can you go to the next slide, please, Ryan? Thank you. So in these cases, we've seen cases where vaccination policies for influenza have actually been upheld in BC. What we see in these cases is that the scientific evidence is really important to showing whether or not that policy is reasonably necessary. So in this particular BC case, there was a policy that was mandatory in nature that required that employees either become vaccinated or wear a mask that type of policy was deemed to be a reasonable intrusion on employee rights. And if you look at the next slide, this is also a case in BC. This was a case in which the policy required vaccination, but if a worker refused and an outbreak occurred, then that employee was sent home without pay. This policy also was considered to be reasonable in the circumstances. Now, this was also a healthcare setting, so of course, this situation is going to be different. One workplace to the next is not going to have the same considerations. In terms of effective implementation, I mean, as a starting point, assessing what the situation is at your workplace is going to be a really important step. This is not something that can or should be implemented overnight without taking a look at what the risks are in the workplace and what measures might already be in place. And also, we'd recommend that you consider less intrusive measures. So for example, if you were to provide education to your employees about the merits of vaccination once it becomes available, if you were to encourage vaccination with weekly reminders, or if possible, create a vaccination clinic at the workplace, might you get to the point where all or most of your workers are becoming vaccinated without making it mandatory? That's a possibility as well, and you have to weigh that, of course, against the health and safety concerns.
I'll just interrupt just briefly. We are seeing many employers get ahead of the curve on that and begin to develop voluntary vaccination policies along the lines of what Natasha's just described. And there's the expectation that might be just about as effective.
Yeah, thanks, Ryan. And then, of course, if you do decide to implement a policy, some steps that are going to be helpful: providing lots of notice so that nobody's taken by surprise, consulting with employees or unions if applicable. Again, there's lots of different ways to encourage employees to become vaccinated, such as making it available on site, providing incentives of some kind. And then, of course, as we've touched on, be aware that your policy should have consideration of how private or sensitive information is going to be treated, and always be prepared to accommodate where an accommodation is sought and is warranted in the circumstances. So I do want to turn things over to our Q&A, because I do see some questions have come in, but I just want to make sure that everyone's aware of our contact information on this slide. And on the previous slide, we do also have a 24-hour COVID-19 support line that you can reach by phone and by email. So if you have questions, feel free to reach us by any of those means.
Great, thanks, Natasha. We've got, looks like a little more, or maybe a little less than 10 minutes. There's a couple of good questions here. Let me address the first one. The question posed is, could an employee refuse to come to work if their coworkers are not vaccinated? So great question. And you can also sort of rephrase that to align with some of the circumstances that we see here today, which is employees, for the last year in various circumstances have refused or been concerned to come to work because of their COVID-related fears. So the answer to that question is perhaps, right? There may be circumstances where an employee who has a particularly vulnerable state, whether it's an immune deficiency issue or otherwise, might be able to make the case that in their circumstances, they shouldn't be required to attend a workplace where folks aren't vaccinated. But the answer in most cases will be just as it is today. If the employer can demonstrate that they've implemented sufficient safety protocols to reduce the risk of transmission, to a reasonable level, then it won't be reasonable for the employee to refuse to attend work. My advice to employers who are facing this kind of circumstance would be this: begin with a very open conversation with the employee, where the answer isn't strict no right out of the gate, but it's a dialogue to understand what the employee's concerns are and see if you can address those concerns informally. If not, what you're going to end up with is really a unique, COVID-related refusal of unsafe work, and that will be the employee's position. And there are protocols through WorkSafe BC about how to deal with a refusal of unsafe work. We won't get into that here, but they are a very delineated set of steps in terms of dealing with an employee who's refusing to come to work because they feel it's unsafe, and you work through that process, which ultimately involves the contact and adjudication by a field officer from WorkSafe BC. Another question, I'll get this one to you, Nat. I guess I'll read it out here. What are considered legitimate or effective incentives to encourage vaccination?
Yeah, I see a couple of questions on that issue of incentives. And there's no hard and fast rule about that. I mean, I think certainly The question is, well, does that mean I have to pay my employees to get vaccinated? That's not what we're suggesting necessarily. Incentives could even be things like, for example, if it's a more desirable shift where there are, more members of the public and there's a greater opportunity to earn tips, for example, that could incentivize if you decided, okay, well, we're going to put our employees who have been vaccinated because of the health and safety issues, we might give them an incentive in that regard. Of course, you do want to be careful that that is not viewed as a discriminatory act if there are employees who perhaps can't be vaccinated because of medical reasons. But again, just considering what might make a desirable incentive for employees to become vaccinated.
Good, thanks. So let's find another one here. Can an employer ask a potential employee if they have issues wearing a mask? I think the answer to that question is yes. If you're in a workplace where wearing a mask is mandatory and a part of your safety protocol, then I think it's entirely reasonable to ask an employee and ensure that they would intend to follow that safety protocol. So I don't see any problem with that question if masks are mandatory in your workplace.
I see a question here, Ryan, about whether or not if employees choose to not get the vaccine, should the policy outline consequences, for example, must work from home? I mean, if that's a possibility in your workplace, certainly having it be clear that there are, if there are options that can be presented to an employee, then certainly presenting those options is going to benefit the policy. I'm not sure that you would necessarily suggest that there are going to be, disciplinary consequences, but to the extent that you can provide a choice to an employee, like we saw in those cases, for example, if it was a viable option in that influenza case to either choose to be vaccinated or wear a mask, something similar could work in the COVID-19 situation. You don't want to impute directly from that influenza because, of course, the science of influenza and the science from COVID-19 are not going to be exactly the same.
Great. Another question here is, what if an employee refuses to provide medical information for either a mask exemption or a vaccine refusal? So let's deal with the mask piece first, because I think it's easier for us to say that virtually any employer with employees in close contact can have a mandatory mask policy. And if an employee refuses to wear a mask, then you're going to have a dialogue with them to say, okay, you need to explain to me the reasons why. And if they say, well, it's a medical reason why, but I'm not going to talk to you any further about that. It's much like any other discussion you have. If an employee says, I can't wear safety goggles, I can't wear safety boots for a medical reason, you as an employer are not going to be entitled to a diagnosis. You're not able to ask them for their clinical records and to understand precisely what their medical condition is, but you're certainly entitled to say, okay, well, I'm going to need you to prove that. I'm going to need you to supply me with sufficient medical information that confirms that you're unable to wear a mask. And that can be frustrating for employers because sooner or later, somebody can walk into a walk-in clinic and say to the doctor, write me a note that says I can't wear a mask. And yes, that sometimes happens, but there are ways to interact with an employee through correspondence to get reliable medical information to either confirm their position that they medically can't wear a mask or otherwise demonstrate that that's not the case. So the short answer is, you are able to insist on sufficiently reliable medical information if the employee is using that as the reason why they won't wear a mask. Now, vaccines are a little different because the answer to that question depends on whether or not your vaccine policy is mandatory or not. Of course, if it isn't mandatory and the employee refuses, you don't have an issue. If it is mandatory, you're going to be into the exact same Q&A with the employees. What's the reason for it, and is that a justifiable reason? And if it's, for example, a medical reason, then you've triggered the duty to accommodate, and you have to explore ways where you might be able to accommodate that employee either by work from home or a period of absence.
There's another question that's come in. If you have an employee that won't get vaccinated, can you make it mandatory that they wear a mask? So certainly if an employee is not going to be vaccinated, you can implement some other type of safety requirement for that employee. But of course, you want to make sure that whatever decision you're making is backed up by scientific evidence. So that's not something that you want to create as an employer, but make sure that you're operating on the recommendation of, say, WorkSafe BC or some type of scientific expert or medical advice. That's not something that should be kind of created in a vacuum based on sort of what the protocols are at the moment.
So there's a good question. Can we ask a candidate during an interview if they plan to be vaccinated? when it's his or her turn if they say yes but then refuse. So there's a good question. Can we ask that question in the interview? And when I get questions like this, I like to reverse engineer them. What are you going to do with the answer? Right? If you're going to ask the question, like you said in an interview, are you married? Were you planning to have a family? Those are dangerous questions, because what are you going to do with the answer? So here, if I'm going to ask somebody, are they going to be vaccinated? This goes back to your policy. Well, if you have a mandatory vaccination policy and it's justifiable because of the circumstances of your workplace, then it is a legitimate question. And if the person says no, and it's a bona fide occupational requirement to be vaccinated, then they would be disqualified from the candidacy. But if you don't have a mandatory vaccination policy, then you don't really need the answer to that question, and it's not worth asking. Anything new there, Natasha?
No, I think we've got all of the questions so far, unless there's any more that come in.
I don't see any more questions. And actually, in the essence of time, I think we're probably going to have to draw this session to a close. Before we do that, I do have one question that came to me from a participant. And I know that you talked about vaccination policies. Can you draw us to a place where examples of vaccination policies may be housed?
Good question. And I don't think at this point you're going to find one online from any one of the authorities like WorkSafe BC or the Human Rights Tribunal or Employment Standards Branch. That hasn't been developed. And I don't know, Natasha, I'd be a little bit surprised if we saw one of those. As a firm, we're in the midst of developing all sorts of those templates for employers. In fact, I had this conversation this morning. In fact, I had this question this morning. Could you send me a template? And my answer was, well, we're certainly developing all sorts of language that we can plug and play, but we were really doing this in sort of a case-by-case basis. So the short answer is I'm personally not aware of any publicly available sort of catalog or library of such policies. And I can tell you we're in the middle of sort of developing them and fine-tuning them on a case-by-case basis right now.
Okay, great. Well, thank you so much for your response. So really, on behalf of the BC Tourism and Hospitality Conference and today's participants, I'd really like to thank you, Ryan, and Natasha, and of course, Arun. This session has been paramount in understanding a landscape that truly is foreign to most of us, and one that I don't think any of us thought that we were going to have to navigate. But as we all now know, circumstances are arising, and having you here today has been truly invaluable. And the examples that you've used in your presentation, the quality of the questions really validates that this session has resonated with all of us today. So again, our thanks go out to each and every one of you for being here today. I know this session is being recorded. Ryan and Natasha, you've left your emails and contact information on the screen, so thank you very much. This session actually now marks the end of our day of workshops, and perhaps it's even the end of the day for many of you here today, the end of the work week for you. So on behalf of the BC Tourism and Hospitality Conference, we thank you for your participation, whether you've joined us here today, whether you've been part of us all week long. We really hope and trust that this has been informative and valuable time spent with us. So I would really like to thank everyone again for the day, and I look forward to seeing each and every one of you about a year from now in Prince George. But until then, have a great weekend, everyone.
Thank you.
Bye. Thank you.
Thank you. Bye-bye.